of the investigation, so others won't know what witnesses are being called in and what they're saying, to keep that secret for the prosecutor to be able to keep developing the evidence, and to protect the accused, because the accused might not ever be indicted. In this case, all of that information was made public every day. The House Democrats destroyed any analogy, any legitimate analogy to a grand jury, because that was all public. They made no secret that the president was the target. They issued vile calumnies about him every day. And they didn't keep the direction of their investigation secret. Their witness lists were published daily. The direction of the investigation was open, and the testimony that took place was selectively leaked to a compliant media to establish a false narrative about the president. If that sort of conduct had occurred in a real grand jury, that would have been a criminal violation. Prosecutors can't do that. Under Rule 6E of the federal criminal rules, it's a criminal offense to be leaking what takes place in a grand jury. And also, the grand jury explanation provides no rationale whatsoever for the second round of hearings. Remember, after the basement bunker, after the secret hearings where the testimony was pre-screened, then the same witnesses who had already been deposed were put on in a public hearing where the president was still excluded. Ask yourself, what was the reason for that? In every prior presidential impeachment in the modern era where there have been public hearings, the president has been represented by counsel and could cross-examine witnesses. Most attorneys for employees don't know the finer points of executive branch confidentiality interests, of deliberative process privilege, and it's also not their job to protect those interests. They're the personal lawyer for the employee who's testifying, trying to protect that employee from potential legal consequences. We usually have lawyers to protect legal rights. So it makes sense when there is an important legal and constitutionally based right at stake, the executive privilege, that there should be a lawyer there to protect that right for the executive branch. And that's the principle that the Office of Legal Counsel endorsed. This also doesn't raise any insurmountable problems for congressional investigations or finding information. In fact, just as recently as April 2019, the House Committee on Oversight and Government Reform reached an accommodation with the Trump administration after the administration had declined to make someone available for a deposition because of the lack of agency counsel. And that issue was worked out, an accommodation was made, and there was some testimony provided in other circumstances. So it doesn't always result in the kind of escalation that was seen here straight to impeachment. The accommodation process can work things out. House Democrats have pointed to a House rule that excludes agency counsel, but of course a House rule cannot override a constitutional privilege. So those are the three principles that the Trump administration asserted. And now I'd like to turn to the claim that somehow this assertion of these principles created an impeachable offense. The idea that asserting defenses and immunities, legal defenses and immunities in response to subpoenas, acting on advice of the Department of Justice, is an impeachable offense is absurd, and it is dangerous for our government. Let me explain why. House Democrats' obstruction theory is wrong first and foremost because in a government of laws, asserting privileges and rights to resist compulsion is not obstruction. It's a fundamental right. In Bordenkircher versus Hayes, the Supreme Court explained to punish a person because he has done what the law plainly allows him to do is a due process violation of the most basic sort, and for an agent of the state to pursue a course of action whose objective is to penalize a person's reliance on his legal rights is patently unconstitutional. This is a principle that in the past, in the Clinton impeachment, was recognized across the board, that it would be improper to suggest that asserting rights is an impeachable offense. Harvard Law professor Lawrence Tribe said, quote, "The allegations that invoking privileges and otherwise using the judicial system to shield information is an abuse of power that should lead to impeachment and removal from office is not only frivolous, but also dangerous." And Manager Nadler then said that the use of a legal privilege is not illegal or impeachable by itself, a legal privilege, executive privilege. And Minority Leader Schumer in the Clinton impeachment expressed the same view.
To suggest that any subject of an investigation, much less the president, with obligations to the institution of the presidency, is abusing power and interfering with an investigation by making legitimate legal claims using due process and asserting constitutional rights is beyond serious consideration.
And that was exactly correct then, and it's exactly correct now. Now, more important than simply the principle that asserting rights can't be considered obstruction, when the rights the president is asserting are based on executive privilege, when they are constitutionally grounded principles that are essential for the separation of powers and protecting the institution of the office of the presidency, to call that obstruction is to turn the Constitution on its head. Defending the separation of powers cannot be deemed an impeachable offense without destroying the Constitution. Accepting that approach would do permanent damage to the separation of powers And it would allow the House of Representatives to turn any disagreement with the executive over informational demands into a supposed basis for removing the president from office. It would effectively create for us the very parliamentary system that the framers sought to avoid. Because by making any demand for information and goading the executive to a refusal and treating that then as impeachable, the House would effectively be able to function with a no-confidence vote power. Now, that is not the framers' design. The legislative and executive branches frequently clash on questions of constitutional interpretation, including about congressional demands for information. These conflicts have happened since the founding. In 1796, George Washington, first president, resisted demands from Congress for information about the negotiation of the Jay Treaty. And there have been conflicts between the executive and the Congress in virtually every administration since then about congressional demands for information. The Founding Fathers expected the branches to have these conflicts. James Madison pointed out that the legislative, executive, and judicial departments must, in the exercise of their functions, be guided by the text of the Constitution according to its own interpretation of it, each according to its own interpretation of it. It was recognized that there would be friction. Similarly, in Federalist 51, Madison pointed out that the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachment of the others. This is checks and balances, this friction, this clashing between the branches. It is not evidence of an impeachable offense. It's the separation of powers in its practical operation. It's part of the constitutional design. Now, the proper and historically accepted way that these disagreements have been resolved is through the constitutionally mandated accommodations process. Courts have explained that the branches are required to engage in an accommodations process to resolve disagreements where there's a clash over a demand for information. As the D.C. Circuit has explained, when Congress asks for information from the executive branch that triggers, quote, an implicit constitutional mandate to seek optimal accommodation of the needs of the conflicting branches, end quote. The goal is to accommodate the needs of both branches to reach a compromise. If that accommodation process fails, Congress has other tools at its disposal to address a disagreement. The House traditionally has proceeded to contempt, to a vote on a contempt resolution. In recent times, the House has taken the position that it may sue in the courts to determine the validity of its subpoenas and secure an injunction to enforce them. Now, the House managers have pointed out that the Trump administration, when it was sued in the McGahn case and other cases, has taken the view that those cases are not justiciable in Article III courts. That is correct. That is the view of the Trump administration. That was the view of the Obama administration. And so there is that resistance in the court cases to the jurisdiction of the courts to address those. But I think House managers are missing the point when they identify that position that the administration has taken. Because the House cannot claim that they have a mechanism for going to court. They're in court right now asserting that mechanism in the McGahn case. And then simultaneously claim that, well, they don't have to bother with that mechanism, they can jump straight to impeachment. Impeachment under the Constitution is the thermonuclear weapon of interbranch friction. And where there is something like a rifle or a bazooka at the House's disposal to address some friction with the executive branch, that is the next step. It is incrementalism in the Constitution, not jumping straight to impeachment, that is the solution. If the House could jump straight to impeachment, that would alter the relationship between the branches. It would suggest that the House could make itself superior over the executive, dangle the threat of impeachment over any demand for information made to the executive. That's contrary to the framers' plan. Madison explained that where the executive and the legislative branches come into conflict, this is in Federalist 49, he said, quote, "Neither of them, it is evident, can pretend to an exclusive or superior right of settling the boundaries between their respective powers," end quote. But that is exactly what the House managers have asserted in this case. They have said that the House becomes supreme, there's no need for them to go to court, the executive must be wrong, any resistance to their subpoena is obstruction. If you claim that our subpoena is invalid, we don't have to do anything to address that concern. We will just impeach you because resistance is obstruction of Congress. And the House Committee even put it this way in their report, the Judiciary Committee. They said that the House itself, they effectively have said that the House is the judge of its own powers because what they said was, quote, "The Constitution gives the House the final word," end quote. That's on page 154 of the House Judiciary Committee report. And what that is essentially saying, they point to the fact that Article 1, Section 2 gives the House the sole power of impeachment. And they claim that because it's the sole power of impeachment, the courts have no role, the House is the final word, it's the judge of its own powers. But that's contrary to the constitutional design. There is no power that is unchecked in the Constitution. The sole power of impeachment given to the House simply means that that power is given solely to the House, not anywhere else. The Constitution does not say that the power of impeachment is the paramount power that makes all other constitutional rights and privileges and prerogatives of the other branches fall away. The framers recognized that there could be partisan impeachments, there could be impeachments for the wrong reasons, and they did not strip the executive branch of any of its means for protecting its own sphere of authority, its own prerogatives under the Constitution. Those principles of executive privilege, those immunities still survive, even in the context of impeachment. The power of impeachment is not like the House can simply flip a switch and say, now we're in impeachment, and they have constitutional kryptonite that makes the powers of the executive eliminated. So when there are these conflicts, even in the context of an impeachment inquiry, the executive can continue to assert its privileges and prerogatives under the Constitution, and indeed it must, in order to protect the institutional interests of the office of the presidency and to preserve the proper balance between the branches under the Constitution. Professor Turley rightly pointed out that by claiming Congress can demand any testimony or documents and then impeach any president who dares to go to the courts, House Democrats were advancing a position that was, quote, entirely untenable and abusive of an impeachment, end quote. Other scholars agree. In the Clinton impeachment, Professor Susan Lowe Block testified that, quote, impeaching a president for invoking lawful privileges is a dangerous and ominous precedent, end quote. It would achieve exactly the result that Gouverneur Morris, one of the framers, warned against at the Constitutional Convention. He explained that, quote, when we make him, referring to the president, amenable to justice, however, we should take care to provide some mode that will not make him dependent on the legislature, end quote. That is exactly what this article of impeachment would do. It would make the president dependent on the legislature, because any demand for information made by Congress could be used as a threat of impeachment to enforce compliance by the executive. And the very theory that the House Democrats have asserted is that there can be no assertions of privileges, no constitutionally based prerogatives of the executive to stand in the way. If that theory were true, virtually every president could have been impeached. Virtually every president has asserted at one time or another these constitutional prerogatives. President Obama famously, in the Fast and Furious investigation, refused to turn over documents that led to his attorney general being held in contempt. But that didn't lead to impeachment. And there could be a long list. Professor Turley testified there'd be a very long list of presidents who would have to be distinguished if the principles being asserted now, in this case, were applied to all past presidents in history. Now, the House Democrats have given a few different justifications for this approach, but I would submit none can be reconciled with the Constitution. They say that if we cannot impeach the President for this obstruction, then the President is above the law. Not so. As I think I've pointed out, the President is staying within the law, asserting the law, relying on the legal advice from the Department of Justice to make his arguments based on long-recognized constitutional principles, and indeed is making the fundamental point with respect to the subpoenas that it is Congress that is not above the law. It's the House. The House has to follow the law as well, has to issue valid subpoenas. And if the law isn't followed, those subpoenas are null and void, and the executive doesn't have to comply with them. The House Democrats say that they shouldn't go to the courts because the courts have no role in impeachment. I think I've pointed out that the House Democrats can't say that they have just because of the provision of the sole power of impeachment, that it's the paramount power and that no other branch plays any role in providing a check on how that power is exercised. And in addition, the House Democrats have gone to court. In the McGahn case that they're litigating right now, they have asserted that that is part of the impeachment inquiry. The Trump administration has explained that it was not validly part of the impeachment inquiry, but that is the ground on which they are litigating that. They say that they have no time for the courts. I think what that really means is they have no time for the rule of law in the way that they're pursuing the inquiry. The other day, one of the House managers actually said on the floor of the Senate that they had to get moving. They couldn't wait for litigation because they had to impeach the president before the election. That's not a valid reason to not pursue litigation in the courts. And I think it's relevant to bear in mind, what sort of delay are we talking about? In the McGahn case that the House managers referred to a number of times, which they had pointed out they presented as being very long and drawn out, they issued a subpoena in April, but they did not file a lawsuit until August. By November 25th, they had a decision from the district court, and it was argued on appeal in the D.C. Circuit on January 3rd. For litigation, that's pretty fast, and it can go faster. In the Nixon case, during Watergate, the special prosecutor issued a subpoena on April 18th, 1974. On May 20th, so in less than a month, the district court denied a motion to quash the subpoena. On May 31st, the Supreme Court agreed to hear the case, granting cert before judgment in the Court of Appeals, and on July 24th, the Supreme Court issued a decision. That's lightning fast. So when there is urgency to the case, when there is a reason for it, there can be expedition in the courts, and a decision can be had in a timely manner. In the one case that actually arose from these impeachment proceedings, it was the House that derailed the case. This was the case involving Deputy National Security Advisor Charlie Kupperman, because when he received a subpoena, he went to court and asked the court for a declaratory judgment explaining what his obligations were. Should he take the directive from the president that he was immune and not go, or should he obey the subpoena? Now, in that case, he filed suit on October 25th. The court, within a few days, set an expedited briefing schedule, but the House withdrew the subpoena on November 5th, just 11 days later, in order to moot the case. So I think litigation is a viable avenue, along with the accommodation process as a first step. Then if the House believes that it can go to court and wants to litigate the jurisdiction and litigate the validity of its subpoenas, that's also available to them. But impeachment, as the first step, doesn't make any sense. And I should point out, in part, when the House managers say they didn't have time to litigate, they didn't have time to go to the courts, but they now come to this chamber and say, this chamber should issue some more subpoenas, this chamber should get some witnesses that we didn't bother to fight about. What do you think will happen then? That there won't be similar assertions of privilege and immunity, that there wouldn't be litigation about that? Again, this goes back to the point that I made. If you put your imprimatur on a process that was broken and say, yes, that was a great way to run things, this was a great package to bring here, and we'll clean up the mess and issue subpoenas and try to do all the work that wasn't done, then that becomes the new normal. And that doesn't make sense for this body. The proper way to have things handled is to have the House, if it wants to bring an impeachment here ready for trial, it has to do the investigation. The information it wants to get, if there's going to be resistance, that has to be resolved, and it has to be ready to proceed, not transfer the responsibility to this chamber to do the work that hasn't been done. They also assert that President Trump's assertion of these privileges is somehow different because it's unprecedented and it's categorical. Well, it's unprecedented perhaps in the sense that there was a broad statement that a lot of subpoenas wouldn't be complied with, but that's because it was unprecedented for the House to begin these proceedings without voting to authorize a committee to issue the subpoenas. That was the first unprecedented step. That's what had never happened before in history. So of course the response to that would be in some sense unprecedented. And the President simply pointed out that without that vote, there were no valid subpoenas. And there have also been categorical refusals in the past. President Truman, when the House Committee on Un-American Activities in 1948 issued subpoenas to his administration, issued a directive to the entire executive branch that any subpoena or demand or request for information, reports, or files of the nature described in those subpoenas shall be respectfully declined on the basis of this directive, and he referred all such inquiries to the office of the President for such response as the President may determine to be in the public interest. And the Truman administration responded to none of them. A last point on the House Democrats' claim that the privileges simply disappear because this is the impeachment power of the House. They have referred a number of times to United States versus Nixon, the Supreme Court decision, suggesting that that somehow determines that when you're in an impeachment inquiry, executive privilege falls away. Well, that's not true. In fact, United States versus Nixon was not even actually addressing a congressional subpoena. It was a subpoena from the special prosecutor. And even in that context, the court did not say that executive privilege simply disappears. Instead, this court said, quote, "It is necessary to resolve these competing interests." They're the interest of the judicial branch in administering a criminal prosecution, a case where the evidence was needed. These competing interests in a manner that preserves the essential functions of each branch. And it even held out the possibility that in the field of foreign relations and national security, there might be something approaching an absolute executive privilege. And that's exactly the field that we're in this case, foreign relations and national security matters. Another thing that you've heard is that President Clinton voluntarily cooperated with the investigation that led to his impeachment, produced tens of thousands of documents. But that's not really accurate. That was only after long litigation again and again about assertions of privilege. He asserted numerous privileges. The House Judiciary Committee then explained, quote, "During the Lewinsky investigation, President Clinton abused his power through repeated frivolous assertions of executive privilege by at least 5 of his aides," end quote. Unlike the House in this case, independent counsel Starr first negotiated with the White House and then litigated those claims and got them resolved. Ultimately, the House managers argue that all of the problems with their obstruction theory should be brushed aside, and the President's assertions of immunities and defenses have to be treated as something nefarious, because as Mr. Nadler put it, only guilty people try to hide the evidence. That's what he said last Tuesday night. And Mr. Schiff similarly said in discussing the assertion of the executive branch's constitutional rights that, quote, "the innocent do not act this way," end quote. Really? Is that the principle in the United States of America? That if you assert legal privileges or rights, that means you're guilty? that the innocent don't assert their rights, that the president can't defend the constitutional prerogatives of his office? That doesn't make any sense. At bottom, the second article of impeachment comes down to a dispute over a legal issue relating to constitutional limits on the ability of the House to compel information from the executive. No matter how House Democrats try to dress up their charges, a difference of legal opinion does not rise to the level of impeachment. Until now, the House has repeatedly rejected attempts to impeach presidents based on legal disputes over assertions of privilege. As Judge Starr pointed out, in the Clinton proceeding, the House Judiciary Committee concluded that the president had improperly exercised executive privilege, yet still concluded that it did not have the ability to second-guess the rationale behind the president or what was in his mind asserting executive privilege, and that it could not treat that as an impeachable offense. It rejected an article of impeachment based on Clinton's assertions of privilege. And as the House Democrats' own witness, Professor Gerhardt, has explained, in 1843, President Tyler similarly was investigated for potential impeachment. His attempts to protect and assert what he regarded as the prerogatives of his office, because he had resisted demands for information from Congress. Professor Gerhardt explained that Tyler's attempts to protect and assert what he regarded as the prerogatives of his office were a function of his constitutional and policy judgments, and they could not be used, the Congress determined, to impeach him. President Trump's resistance to congressional subpoenas was no less a function of his constitutional and policy judgments, and it provides no basis to impeach him. I'd like to close with a final thought. One of the greatest issues, and perhaps the greatest issue for your consideration in this case, is how the precedent set in this case will affect the future. The framers recognized that there would be partisan and illegitimate impeachments. Hamilton expressly warned in Federalist Number 65 about impeachments that reflected what he called, quote, the persecution of an intemperate or designing majority in the House of Representatives, end quote. That is exactly what this case presents. And Justice Story recognized that the Senate provided the proper tribunal for trying impeachments because it was believed by the framers to have a greater sense of obligation to the future, to future generations, not to be swayed by the passions of the moment. And one of the essential questions here is, will this chamber adopt a standard for impeachment, a diluted standard, that fundamentally disrupts, damages, alters the separation of powers in our constitutional structure of government? Because that is what both the first article, for reasons that Judge Starr and Professor Dershowitz have covered, and the second article, the obstruction charge, would do. And so I'll close just with a quotation from one of the Republican senators who crossed the aisle and voted against convicting President Andrew Johnson during his impeachment trial. It was Lyman Trumbull, who explained, I think, the great principle that applies here. He said, quote, once we set the example of impeaching a president for what, when the excitement of the hour shall have subsided, will be regarded as insufficient causes, no future president will be safe. And what then becomes of the checks and balances of the Constitution, so carefully devised and so vital to its perpetuity? They are all gone. Thank you, Mr. Chief Justice. I'll yield to Mr. Sekulow.
Mr. Chief Justice, members of the Senate, House managers. Mr. Feldman talked about the importance, just concluded on the importance of executive privilege. Professor Turley, who testified before the House, said we have 3 branches of government, not 2. If you impeach a president, if you make a high crime and misdemeanor out of going to court, it is an abuse of power. It's your abuse of power. With regard to executive privilege, it was Mr. Nadler who called it executive privilege and other nonsense. When Attorney General Holder refused to comply with subpoenas, President Obama invoked executive privilege, arguing, and I quote, "compelled disclosure would be inconsistent with the separation of powers established in the Constitution." Executive power and other nonsense. Manager Schiff wrote that the White House assertion of executive privilege was backed by decades of precedent that has been recognized and has recognized the need for the President and his senior advisors to receive candid advice and information from their top aides. Executive privilege and other nonsense. The nonsense, we talked about this the other night, is to treat the separation of powers and constitutional privileges as if they're asbestos in the ceiling tiles. You can't touch them. That's not the way the Constitution is designed. We're going to now turn our attention to a separate topic. It's one that was been discussed a lot on the floor here and will be discussed now. Presenting for the President is the former Attorney General for the state of Florida, Pam Bondi. She is also a prosecutor, a career prosecutor. She's handled countless cases. She's going to discuss an issue that the House managers have put pretty much at the center of their case, and that's the issue of corruption in Ukraine, particularly with regard to a company known as Burisma. I yield my time, Mr. Chief Justice, to former Attorney General Pam Bondi.
Chief Justice. Senators. Members of the Senate. When the House managers gave you their presentation, when they submitted their brief, they repeatedly referenced Hunter Biden and Burisma. They spoke to you for over 21 hours, and they referenced Biden or Burisma over 400 times. And when they gave these presentations, they said there was nothing to see, it was a sham. This is fiction. In their trial memorandum, the House managers described this as baseless. Now, why did they say that? Why did they invoke Biden or Burisma over 400 times? The reason they needed to do that is because they are here saying that the President must be impeached and removed from office for raising a concern. And that's why we have to talk about this today. They say sham, they say baseless, because they say this because if it's okay for someone to say, hey, you know what, maybe there's something here worth raising, then their case crumbles. Because they have to prove beyond a reasonable doubt that there is no basis to raise this concern. But that's not what public records show. Here are just a few of the public sources that flagged questions surrounding this very same issue. The United Kingdom Serious Fraud Office, Deputy Assistant Secretary of State George Kent, Hunter Biden's former business associate, an ABC White House reporter, Good Morning America, ABC, The Washington Post, The New York Times, Ukrainian law enforcement, and the Obama State Department itself. They all raised this issue. We would prefer not to be talking about this. We would prefer not to be discussing this. But the House managers have placed this squarely at issue, so we must address it. Let's look at the facts. In early 2014, Joe Biden, our Vice President of the United States, led the United States foreign policy in Ukraine with the goal of rooting out corruption. According to an annual study published by Transparency International, during this time, Ukraine was one of the most corrupt countries in the entire world. In Ukraine, there's a natural gas company called Burisma. Burisma has been owned by an oligarch named Mykola Zlochevsky. Here's what happened very shortly after Vice President Biden was made U.S. point man for Ukraine. His son, Hunter Biden, ends up on the board of Burisma, working for and paid by the oligarch Zlochevsky. In February 2014, in the wake of anti-corruption uprising by the people of Ukraine, Zlochevsky flees the country, flees Ukraine. Zlochevsky, the oligarch, is well known. George Kent, the very first witness that the Democrats called during their public hearings, testified Zlochevsky stood out for his self-dealings even among other oligarchs. House managers didn't tell you that. Ambassador Kurt Volkler explained that Burisma had a, quote, very bad reputation as a company for corruption and money laundering, end quote. House managers didn't tell you that. Burisma was so corrupt that George Kent said he intervened to prevent U.S. aid from co-sponsoring an event with Burisma. You know what this event was? It was a child's contest, and the prize was a camera. They were so bad, Burisma, that our country wouldn't even co-sponsor a children's event with Burisma. In March 2014, the United Kingdom Serious Fraud Office opens a money laundering investigation into the oligarch Zlochevsky and his company Burisma. The very next month, April 2014, according to a public report, Hunter Biden quietly joins the board of Burisma. Remember, early 2014 was when Vice President Biden began leading Ukraine policy. Here's how Hunter Biden came to join Burisma's board in April 2014. He was brought on the board by Devon Archer, his business partner. Devon Archer was college roommates with Chris Hines, stepson of Secretary of State John Kerry. All three men, Hunter Biden, Devon Archer, and Chris Hines, had all started an investment firm together. Public records show that April 16, 2014, Devon Archer meets with Vice President Biden at the White House. Just 2 days later, on April 18, 2014, is when Hunter Biden quietly joins Burisma, according to public reporting. Remember, this is just 1 month after the United Kingdom Serious Fraud Office opened a money laundering case into Burisma. Hunter Biden joins their board. And not only 10 days after Hunter Biden joins the board, British authorities seize $23 million in British bank accounts connected to the oligarch Zlochevsky, the owner of Burisma. Did Hunter Biden leave the board then? No. The British authorities also announced that it had started a criminal investigation into potential money laundering. Did Hunter Biden leave the board? No. What happened was then, only then, did the company choose to announce that Hunter Biden had joined the board after the assets of Burisma and his oligarch owner, Zlochevsky, were frozen and a criminal investigation had begun. Hunter Biden's decision to join Burisma raised flags almost immediately. One article from May 2014 stated, "The appointment of Joe Biden's son to the board of Ukrainian gas firm Burisma has raised eyebrows the world over. Even an outlet with bias for Democrats pointed out Hunter Biden's activities created a conflict of interest for Joe Biden. The article stated, the move raises questions about a potential conflict of interest for Joe Biden. Now, even Chris Hines, Hunter Biden's own business partner, had grave concerns. He thought that working with Burisma was unacceptable. This is Chris Hines. He was worried about the corruption, the geopolitical risk, and how bad it would look. So he wisely distances himself from Hunter Biden and Devon Archer's appointments to Burisma. He didn't simply call his stepfather, Secretary of State, and say, I have a problem with this. He didn't tell his friends, hey guys, I'm not getting on the board, I want nothing to do with this. He went so far as to send an email to senior State Department officials about this issue. This is Chris Hines. He wrote, apparently, Devon and Hunter have joined the board of Burisma, and a press release went out today. I can't speak to why they decided to, but there is no investment by our firm in their company. What did Hunter Biden do? He stayed on the board. What did Chris Hines do? He subsequently stopped doing business with his college roommate, Devon Archer, and his friend, Hunter Biden. Chris Hines' spokesperson said, the lack of judgment in this matter was a major catalyst for Mr. Hines ending his business relationship with Mr. Archer and Mr. Biden. Now, the media also noticed. The same day, an ABC News reporter asked Obama White House Press Secretary Jay Carney about it. Here's what happened.
Hunter Biden has now taken a position with the largest oil and gas company, holding company in Ukraine. Is there any concern about at least the appearance of a conflict there? See the vice president.
I would refer you to the vice president's office. I saw those reports. Hunter Biden and other members of the Biden family are obviously private citizens, and where they work is not does not reflect an endorsement by the administration or by the vice president or president. But I would refer you to the vice president's office.
The next day, the Washington Post ran a story about it. It said, the appointment of the vice president's son to a Ukrainian oil board looks nepotistic at best, nefarious at worst. Again, the appointment of the vice president's son to a Ukrainian oil board looks nepotistic at best, nefarious at worst. And the media didn't stop asking questions here. It kept going. Here's ABC.
You have to fight the cancer of corruption.
But then, something strange happened. Just 3 weeks later, a Ukrainian natural gas company, Burisma, accused of corruption, appoints Hunter Biden, seen here in their promotional videos, to their board of directors, paying his firm more than $1 million a year.
Here's more from ABC. Continued on.
And Ukraine wasn't the only country where Hunter Biden's business and his father's diplomacy as vice president intersected. It also happened in China.
This video shows Chinese diplomats greeting Vice President Biden as he arrived in Beijing in December of 2013. Right by his side, his son Hunter. Less than 2 weeks later, Hunter's firm had new business, creating an investment fund in China involving the government-controlled Bank of China. With reports, they hope to raise $1.5 billion.
In fact, every witness who was asked about Hunter Biden's involvement with Burisma agreed there was a potential appearance of a conflict of interest. Multiple House Democrat witnesses, including those from the Department of State, the National Security Council, and others unanimously testified there was a potential appearance of a conflict of interest. These were their witnesses. How much money did Hunter Biden get for being on the board? Well, you start looking at this bank records. According to reports, between April 2014 and October 2015, Burisma paid more than $3.1 million to Devon Archer and Hunter Biden. That's over the course of a year and a half. How do we know this? Some of Devon Archer's bank records were disclosed during an unrelated federal criminal case having nothing to do with Hunter Biden. These bank records show 17 months that Burisma wired two payments of $83,333, not just for 1 month, for 2 months, for 3 months, but for 17 months. According to Reuters, sources report that of the two payments of $83,333 each, one was for Hunter Biden and one Devon Archer. Now, Hunter Biden was paid significantly more than board members for major U.S. Fortune 100 companies, such as Goldman Sachs, Comcast, Citigroup. The typical board member of these Fortune 100 companies, we know they're titans of their industry, they're highly qualified, and as such, they're well compensated. Even so, Hunter Biden was paid significantly more. This is how well he was compensated. So Hunter Biden is paid over $83,000 a month, while the average American family of four during that time, each year, made less than $54,000. And that's according to U.S. Census Bureau during that time. And this is what's been reported about his work on the board. The Washington Post said, quote, "What specific duties Hunter Biden carried out for Burisma are not fully known," end quote. The New Yorker reported, quote, "Once or twice a year, he attended Burisma board meetings and energy forums that took place in Europe," end quote. When speaking with ABC News about his qualifications to be on Burisma's board, Hunter Biden didn't point to any of the usual qualifications of a board member. Hunter Biden had no experience in natural gas, no experience in the energy sector, no experience with Ukrainian regulatory affairs. As far as we know, he doesn't speak Ukrainian. So naturally, the media has asked questions about his board membership. Why was Hunter Biden on this board?
If your last name wasn't Biden, do you think you would have been asked to be on the board of Burisma?
I don't know. Probably not.
So let's go back and talk about his time on the board. Remember, he joined Burisma's board April 2014, while the United Kingdom had an open money laundering case against Burisma and its owner, the oligarch Zlochevsky. On August 20th, 2014, 4 months later, the Ukrainian Prosecutor General's office initiates a money laundering investigation into the same oligarch, Zlochevsky. This is one of 15 investigations into Burisma and Zlochevsky, according to a recent public statement made by the current Prosecutor General. On January 16, 2015, prosecutors put Zlochevsky, the owner of Burisma, on whose Hunter Biden sat on his board, on the country's wanted list for fraud, while Hunter Biden's on the board. Then a British court orders Zlochevsky's $23 million in assets be unfrozen. Why was the money unfrozen? Deputy Assistant Secretary Kent testified to it.
Somebody in the General Prosecutor's Office of Ukraine shut the case, issued a letter to his lawyer, and that money went poof.
So essentially paid a bribe to make the case go away.
That is our strong assumption, yes, sir.
He also testified that the Ukrainian Prosecutor General's office's actions led to the unfreezing of the assets. After George Kent's confirmation, that prosecutor was out. Victor Shokin becomes the prosecutor general. This is the prosecutor that you'll hear about later, the one that Vice President Biden has publicly said he wanted out of office. In addition to flagging questions about previous prosecutors' actions, George Kent also specifically voiced other concerns, this time to the Vice President's office about Hunter Biden. In February 2015, he raised concerns about Hunter Biden to Vice President Biden's office.
In a briefing call with the National Security Staff of the Office of the Vice President in February of 2015, I raised my concern that Hunter Biden's status as a board member could create the perception of a conflict of interests.
But House managers didn't tell you that. This is all while Hunter Biden sat on Burisma's board. Did Hunter Biden stop working for Burisma? No. Did Vice President Biden stop leading the Obama administration's foreign policy efforts in Ukraine? No. In the meantime, Vice President Biden is still at the forefront of the U.S.-Ukraine policy. He pledges $1 billion loan guarantee to Ukraine, contingent on its progress in rooting out corruption. Around the same time of the $1 billion announcement, other people raised the issue of a conflict. As Obama administration's special envoy for energy policy told The New Yorker, it raised Hunter Biden's participation on the board of Burisma. He raised it directly with the vice president himself. This is a special envoy to President Obama. And the media had questions too. December 8, 2015, the New York Times publishes an article that Prosecutor General Shokin was investigating Burisma and its owner, Zlochevsky. The Times report, here's their quote, the credibility of the vice president's anti-corruption message may have been undermined by the association of his son, Hunter Biden, end quote, with Burisma and its owner, Zlochevsky. And it wasn't just one reporter who asked questions about the line between Burisma and the Obama administration. As we learned recently through reporting on Fox News, on January 19, 2016, there was a meeting between Obama administration officials and Ukrainian prosecutors. Ken Vogel, journalist for the New York Times, asked the State Department about this meeting. He wanted more information about the meeting, quote, where U.S. support for prosecutions of Burisma holdings in the United Kingdom and Ukraine were discussed, end quote. But the story never ran. Around the time of the reported story, January 2016, meeting between the Obama administration and Ukrainian officials took place, according to a Ukrainian press report, as translated, says, quote, the U.S. Department of State made it clear to the Ukrainian authorities that it was linking the $1 billion in loan guarantees to the dismissal of Prosecutor General Victor Shokin, end quote. Now, we all know from the Obama administration and from the words of Vice President Biden himself, he advocated for the Prosecutor General's dismissal. There was ongoing investigation into the oligarch Zlochevsky, the owner of Burisma, at the time. We know this because on February 2nd, 2016, the Ukrainian Prosecutor General obtained a renewal of a court order to seize the Ukrainian oligarch's assets. A Kiev Post article published on February 4th, 2016, says the oligarch Zlochevsky is, quote, suspected of committing a criminal offense of illicit enrichment, end quote. Over the next few weeks, the Vice President had multiple calls with Ukraine's President Poroshenko. Days after the last call, on February 24th, 2016, a D.C. consultant reached out to the State Department to request a meeting to discuss Burisma. We know what she said because the email was released under the Freedom of Information Act. The consultant explicitly invoked Hunter Biden's name as a board member. In an email summarizing the call, the State Department official says that the consultant, quote, noted that 2 high-profile citizens are affiliated with the company, including Hunter Biden as a board member, end quote. She added that the consultant would, quote, like to talk with Undersecretary of State Novelli about getting a better understanding of how the U.S. came to the determination that the country is corrupt, end quote. To be clear, this email documents that the U.S. government had determined Burisma to be corrupt. And the consultant was seeking a meeting with an extremely senior State Department official to discuss the U.S. government's position. Her pitch for the meeting specifically used Hunter Biden's name, and according to the email, the meeting was set for a few days later. And later that month, on March 29, 2016, the Ukrainian parliament finally votes to fire the prosecutor general. This is the prosecutor general investigating the oligarch, owner of Burisma, on whose board Hunter Biden sat. 2 days after the prosecutor general is voted out, Vice President Biden announces that the U.S. will provide $335 million in security assistance to Ukraine. He soon announces that the U.S. will provide $1 billion in loan guarantees to Ukraine. Now let's talk about one of the Democrats' central witnesses, Ambassador Yovanovitch. In May 2016, Ambassador Yovanovitch was nominated to be ambassador in Ukraine. Here's what happened when she was preparing for her Senate confirmation hearing.
Congresswoman Stefanik had asked you how the Obama-Biden State Department had prepared you to answer questions about Burisma and Hunter Biden specifically. You recall that?
Yes.
Out of thousands of companies in the Ukraine, the only one that you recall the Obama-Biden State Department preparing you to answer questions about was the one where the vice president's son was on the board. Is that fair?
Yes.
So she's being prepared to come before all of you, and talk about world issues, going to be in charge of the Ukraine. And what did they feel, the only company, the company that it was important to brief her on in case she got a question? Burisma. Ambassador Yovanovitch was confirmed July 2016 as the Obama administration was coming to a close. In September 2016, a Ukrainian court cancels the oligarch Zlochevsky's arrest warrant for lack of progress in the case. In mid-January 2017, Burisma announces that all legal proceedings against it and Zlochevsky have been closed. Both of these things happened while Hunter Biden sat on the board of Burisma. Around this time, Vice President Biden leaves office. Years later now, former Vice President Biden publicly details what we know happened, his threat to withhold more than $1 billion in loan guarantees unless Shokin was fired. Here's the Vice President.
I said, no, I'm not going to, or we're not going to give you the $1 billion. They said, you have no authority. You're not the president. The president said. I said, call him. I said, I'm telling you, you're not getting the $1 billion. I said, you're not getting the $1 billion. I'm going to be leaving here. And I think it was, 6 hours? I looked, I said, I'm leaving in 6 hours. If the prosecutor's not fired, you're not getting the money. Well, son of a bitch. Got fired. And they put in place someone who was solid at the time.
What he didn't say on that video, according to the New York Times, this was the prosecutor investigating Burisma, Shokin. What he also didn't say on the video was that his son was being paid significant amounts by the oligarch, owner of Burisma, to sit on that board. Only then does Hunter Biden leave the board. He stays on the board until April 2019. Now, in November 2019, Hunter Biden signs an affidavit saying, quote, He's been unemployed and has no other monthly income since May 2019. This was in November of 2019, so we know from after April 2019 to May 2019 through November 2019, he was unemployed by his own statement. April 2019 to November 2019. Despite his resignation from the board, the media has continued to raise the issue relating to a potential conflict of interest. On July 22, 2019, the Washington Post wrote, the fired prosecutor general Shokin, quote, believes his ouster was because of his interest in the company, end quote, referring to Burisma. The Post further wrote that, quote, had he remained in his post, he would have questioned Hunter Biden. On July 25th, 2019, 3 days later, President Trump speaks with President Zelensky. He says, the other thing, there's a lot of talk about Biden's son, that Biden stopped the prosecution, and a lot of people want to find out about that. So whatever you can do with this Attorney General would be great. Biden went around bragging that he stopped the prosecution. So if you can look into it, it looks horrible to me. End quote. The House managers talked about the Bidens of Burisma 400 times, but they never gave you the full picture. But here are those who did. The United Kingdom Serious Fraud Unit, Deputy Assistant Secretary of State George Kent, Chris Hines, the ABC White House reporter, ABC, Good Morning America, The Washington Post, The New York Times, Ukrainian law enforcement, and the Obama State Department itself. They all thought there was cause to raise the issue about the Bidens and Burisma. Now the House managers might say, without evidence, that everything we just have said has been debunked, that the evidence points entirely and unequivocally in the other direction. That is a distraction. You've heard from the House managers. They do not believe that there was any concern to raise here, that all of this was baseless. And all we are saying is that there was a basis to talk about this, to raise this issue, and that is enough. I yield my time.
Thank you, Mr. Chief Justice. Majority Leader McConnell, Democratic Leader Schumer, House managers, members of the Senate, this will be our last presentation before dinner. The next lawyer representing the President is Eric Hirschman. He's a partner in the Kasowitz firm, a law firm which has been representing the President for over 2 decades. He's a former prosecutor and trial lawyer, and he ran a natural gas company in the United States. He is going to discuss additional evidence the House managers ignored or misstated and how other presidents might have measured up under this new impeachment standard.
Mr. Chief Justice, members of the Senate, I am Eric Hirschman. I have the honor and privilege of representing the President of the United States in these proceedings. I have been carefully listening to and reviewing the House manager's case. That case pretty much boils down to one straightforward contention, that the President abused his power to promote his own personal interest and not our country's interests. The House managers say that the President did not take the steps that they allege for the benefit of our country, but only for his own personal benefit. But if that's wrong, if what the President had wanted would have benefited our country, then the managers have not met their burden, and these articles of impeachment must be rejected. As we will see, the House managers do not come close to meeting their burden. Last week, Manager Schiff said that the investigations President Trump supposedly asked President Zelensky about on the July 25th call could not have been in the country's interest because he said they were, quote unquote, discredited entirely. The House managers say that the investigations had been debunked. They were sham investigations. So now we have the question, were they really? The House managers, in the over 21 hours of the repetitive presentation, never found the time to support those conclusory statements. Was it in fact true that any investigation had been debunked? The House managers do not identify for you who supposedly conducted any investigations, who supposedly did the debunking, who discredited it, where and when were any such investigations conducted, when were the results published, and much more is left unanswered. Attorney General Bondi went through for you some of what we know about Burisma and its millions of dollars in payments to Vice President Biden's son and his son's business partner. There is no question that any rational person would like to understand what happened. I'm going to go through some additional evidence which was easily available to the House managers, but which they never sought or considered. Based on what Attorney General Bondi told you in this additional evidence, you can judge for yourself whether the conduct was suspect. As you know, one of the issues concerned Hunter Biden's involvement with the Ukrainian natural gas company, which paid him millions of dollars while his father was vice president and was in charge of the Ukrainian portfolio during the prior administration. I'll get to those supposedly discredited allegations identified by the House managers in a few minutes. The other issue was what Manager Schiff called, quote, the baseless conspiracy theory that Ukraine, not Russia, interfered in the 2016 election, close quote. Manager Schiff said that President Trump wanted to, quote, erase from history his previous political misconduct, close quote. But there was no previous political misconduct. If any theory has actually been discredited, it's the theory that President Trump colluded with Russia in 2016. It was that theory that was discredited, and discredited entirely by Mr. Mueller's massive investigation, the same investigation the Democrats demanded since President Trump took office, the same investigation they knew, they were absolutely sure would expose such collusion. The same investigation which, after 22 months of exhaustive work, at a cost to the taxpayers of $32 million, found no conspiracy and no evidence of Russian collusion with the Trump campaign. And as we will see, the Democrats are as wrong now about the articles of impeachment as they were in 2016 about the Russian collusion. As to the other incident President Trump mentioned, the one concerning the Ukrainian gas company Burisma, well, I actually think this is something that is undisputed, that Ukraine had a particularly bad corruption problem. It was so corrupt that dealing with corruption and solving the corruption was a priority for our U.S. foreign policy. Here is how one knowledgeable observer of Ukraine put it in 2015, quote, it's not enough to set up a new anti-corruption bureau and establish a special prosecutor fighting corruption. The Office of the General Prosecutor desperately needs reform. The judiciary should be overhauled. The energy sector needs to be competitive, ruled by market principles, not sweetheart deals. It's not enough to push through laws to increase transparency with regard to official sources of income. Senior elected officials have to remove all conflicts between their business interests and their government responsibilities. Now, as Attorney General Bondi said, here are the facts we do know about Hunter Biden's involvement with Ukraine. Burisma, a Ukrainian natural gas company, paid Hunter Biden millions of dollars to serve on its board of directors. He did not have any relevant expertise or experience. He had no expertise or experience in the natural gas industry. He had no known expertise in corporate governance, nor any expertise in Ukrainian law. He doesn't, so far as we know, speak Ukrainian. So why? Why did Burisma want Hunter Biden on its board? Why did they want to pay him millions of dollars? Well, he did have one qualification. He was the son of the Vice President of the United States. He was the son of the man in charge of the Ukrainian portfolio for the prior administration. And we are to believe there is nothing to see here. That for anyone to investigate or inquire about this would be a sham. Nothing to see here. But tellingly, Hunter Biden's attorney on October 13, 2019, issued a statement on his behalf. He indicated that in April 2014, Hunter was asked to join the board of Burisma. Then states Hunter stepped off Burisma's board in April 2019. Now listen to the commitment that Hunter Biden is supposedly willing to make to all of us. Hunter makes the following commitment. Under a Biden administration, Hunter will readily comply with any and all guidelines or standards a President Biden may issue to address purported conflicts of interest or the appearance of such conflicts, including any restrictions related to overseas business interests. That statement almost tells us all we need to know. That's the rule that should have been in place in 2014 because there already was an Obama-Biden administration. What changed? What changed? Remember a couple of minutes ago when I quoted an expert on Ukraine, the one who said that Ukraine must clean up its energy sector, the one who said that Ukraine's senior elected officials have to remove all conflicts between their business interests and their government responsibilities. You know who said that about Ukraine? Vice President Joe Biden in December of 2015. Vice President Biden went to Ukraine approximately 12 to 13 times. He spoke with legislators, business people, officials. He was purportedly fighting corruption in Ukraine. He was urging Ukraine to investigate and uproot corruption. One thing he apparently did not do, however, was to tell his son not to trade on his family connections. He did not tell his son to especially stay away from the energy sector in the very corruption-ridden country Vice President Biden was responsible for. And Manager Schiff says, move along. There's nothing to see here. What are the House managers afraid of finding out? In an interview with ABC in October of last year, Hunter Biden said he was on the board of Burisma to focus on principles of corporate governance and transparency.
Bottom line is that I know that I was completely qualified to be on the board to head up the corporate governance and transparency committee on the board. And that's all that I focused on.
But when asked how much money Burisma was paying him, he responded he doesn't want to open his kimono and disclose how much. He does refer to public reports about how much he was being paid, but as we now know, he was being paid far more than what was in the public record.
You were paid $50,000 a month for your position?
Look, I'm a private citizen. One thing that I don't have to do is sit here and open my kimono as it relates to how much money I make or did or didn't. But it's all been reported.
So what was the real reason that Hunter Biden, the vice president's son, was being paid by Burisma? Was it based on his knowledge and understanding of the natural gas industry in Ukraine? Was he going to discuss how our government regulates the energy industry here? Was he going to discuss how we set gas rates? Was he going to discuss pipeline development, construction, or environmental impact statements? Did he know anything about the natural gas industry at all? Of course not. So what was the reason? I think we do not need to look any further than the explanation that Hunter Biden gave during the ABC interview when he was asked why. Here's what he had to say.
If your last name wasn't Biden, do you think you would have been asked to be on the board of Burisma?
I don't know. I don't know. Probably not. I don't think that there's a lot of things that would have happened in my life that if my last name wasn't Biden.
And as if to confirm how suspect this conduct was, that it should be a concern to our country, Hunter Biden and his lawyer could not even keep their story straight. Compare the press release that was issued by Burisma on May 12, 2014, with Hunter Biden's lawyer statement on October 13th of 2019. The May 2014 press release begins, R for Robert Hunter Biden will be in charge of Holdings Legal Unit. He was going to be in charge of a Ukrainian gas company owned by an oligarch's legal unit. However, in his lawyer's statement in October of 2019, after his involvement with Burisma came under renewed public scrutiny, he now claims at no time was Hunter in charge of the company's legal affairs. Which is it? What was Hunter Biden doing at Burisma in exchange for millions of dollars? Who knows? What were they looking to hide? So much for his corporate governance and transparency. But let's take a step back and realize what actually transpired. Because the House managers would have us believe this had nothing at all to do with our government, nothing at all to do with our country's interests, nothing at all to do with our vice president, nothing at all to do with the State Department. It simply was private citizen Hunter Biden doing his own private business. It was purely coincidental that it was in his father's portfolio in Ukraine, in the exact sector, the energy sector, that his father said was corrupt. But we have a document here again, something that House managers did not show you or even put before the House before voting these baseless articles of impeachment. If you look at this email, it's an email from Chris Hines, and as Attorney Bondi already told you, he is the stepson of the then Secretary of State, John Kerry, and who was the other business partner with Hunter Biden and Devin Archer. Our Secretary of State's stepson and our Vice President's son are in business together. It was sent on May 13, 2014, to the official government email addresses of two senior people at the State Department. And who are these two people? The Chief of Staff to the Secretary of State and the Special Advisor to the Secretary of State. The subject line in the email is not corporate transparency. It's not corporate governance. It's not, here's a heads up. The subject line is Ukraine. Chris Hines certainly understood the sensitivity to our U.S. foreign policy. And what does the Secretary of State's stepson say about Hunter Biden and Devin Archer? He says this. Apparently, Devin and Hunter both joined the board of Burisma, and a press release went out today. I can't speak to why they decided to, but there was no investment by our firm in the company. What is the most telling thing about this? It is clear that the Chief of Staff and the Special Assistant to the Secretary already knew who Devin was because Mr. Hines did not include his last name. It's just Devin. And they obviously knew who Hunter was because, again, it's Hunter Biden. This is Chris Hines saying, I can't speak to why they decided to join the board of Burisma. He's their business partner. Not that there are good corporate reasons and they're going there for corporate government. Not that they're there to enhance corporate transparency. Not that they are there to further U.S. policy. Not that they are there to help fight corruption in Ukraine. Not that they are there to ensure that boards of directors' compensation and benefits are publicly disclosed. Nothing like that. He cannot say those things because he knows Devin and Hunter well. And he knows they have no particular qualifications whatsoever to do those things, especially for a Ukrainian gas company. Instead, Mr. Hines is plainly going on the record to report what Hunter and Devin were doing through official channels and to take pains to disassociate himself from what they were doing. And what did the State Department do with this information that the Secretary of State's stepson thought they needed to know? Apparently, nothing. They did not tell Mr. Hines to stay away. They did not tell Mr. Hines there's no problem. Nothing. But all this, the House managers want us to believe, does not even merit any inquiry. Anyone asking for one anyone discussing one is now corrupt. Does it merit an inquiry why a corrupt company in a corrupt country would be paying our Vice President's son $1 million per year, plus it appears some additional expenses, and paying his business partner an additional $1 million per year? Secretary of State Kerry's stepson thought it was important enough to report. Why aren't the House managers concerned? And I ask you, why would it not merit an investigation? And you know something else about Vice President Biden? Well, back in January of 2018, as you heard, former Vice President Biden bragged that he had pressured the Ukrainians, threatened them, indeed coerced them, into firing the state prosecutor who reportedly was investigating the very company that paid millions of dollars to his son. He bragged that he gave them 6 hours to fire the prosecutor, or he would cut off $1 billion in U.S. loan guarantees.
I said, no, I said, I'm not going to, or we're not going to give you the $1 billion. They said, you have no authority. You're not the president. The president said. I said, call him. I said, I'm telling you, you're not getting the $1 billion. I said, you're not getting the $1 billion. I'm going to be leaving here. And I think it was, what, 6 hours? I looked, I said, I'm leaving in 6 hours. If the prosecutor's not fired, you're not getting the money. Well, son of a bitch. Got fired. And they put in place someone who was solid at the time.
Are we really to believe that it was the policy of our government to withhold $1 billion? $1 billion of needed guarantees in aid to Ukraine unless they fired a prosecutor on the spot? Was that really our policy? We have all heard continuously from the managers, and many agree about the risks to the Ukrainians posed by the Russians. We have heard the managers say that a slight delay in providing funding to Ukraine endangers our national security and jeopardizes our interests, and therefore the president must immediately be removed from office. Yet they also argue that it was the official policy of our country to withhold $1 billion unless one individual was fired within a certain matter of hours. Was that really, or could it ever be, our United States policy? According to the House manager's theory, we were willing to jeopardize Ukrainians unless somebody who happened to be investigating Burisma was promptly fired. Were we going to jeopardize the Ukrainian economy because a prosecutor was not fired in the 6-hour time period Vice President Biden demanded? Does anyone really believe that was or ever could be our United States foreign policy? And just in case the managers or others try to argue, no, he wasn't serious about that, he was just bluffing, what kind of message would that send to the Russians about our support for the Ukrainians, that we would bluff with the Ukrainian economy? From 2014 to 2017, Vice President Biden claimed to be on a crusade against corruption in Ukraine. He repeatedly spoke about how the cancer of corruption was endemic in Ukraine and hobbled Ukraine, how Ukraine faced no more consequential mission than confronting corruption. And he encouraged Ukraine to close the space for corrupt middlemen who rip off the Ukrainian people. The Vice President railed against monopolistic behavior where a select few profit from so many sweetheart deals that has characterized that country for so long. And on his last official visit to Ukraine, 4 days before he left office, he spoke out against corruption and oligarchy that eats away like a cancer, and against corruption which continues to eat away at Ukraine's democracy within. Why was Vice President Biden doing this? Was he so concerned about corruption in Ukraine, even singling out that country's energy sector? Because corruption in Ukraine is a critical policy concern for our country. But during this whole time, what else was happening? His son and his son's business partner were raking in over $1 million a year for what was regarded as one of the most corrupt Ukrainian companies in the energy sector, owned and controlled by one of the most corrupt oligarchs. Were Vice President Biden's words and advice to Ukraine just hollow? According to the House managers, the answer apparently is yes. They were empty words, at least when it came to anyone questioning his son's own sweetheart deal, his own son's deal with Ukraine's corruption and oligarchy. Again, to raise Manager Schiff's own question, what kind of message did this send to future U.S. government officials? Your family can accept money from foreign corrupt companies? No problem. You can pay family members of our highest government officials, and no one is allowed to even ask questions. What was going on? We have to just accept now the House manager's conclusory statements, like sham, discredited, even though no one has ever investigated. Why? And can you imagine what House Manager Schiff and his fellow Democratic representatives would say if it were President Trump's children on an oligarch's payroll? And when it finally appeared that a true Ukrainian corruption fighter had assumed the country's presidency, President Trump was not supposed to, he was not permitted to, follow up on Vice President Biden's own words about fighting corruption and try to make those words something other than empty. And according to the House managers, Ukrainian corruption is now only a private interest. It no longer is a serious, important concern for our country. Now, I want to take a moment to cover a few additional points about the July 25th telephone call in which the House managers believe that the President in the United States, in their words, was shaking down and pressuring the President of Ukraine to do his personal bidding. First of all, this was not the first telephone call that the President of the United States had with other foreign leaders. So think about this for a moment. The call was routed through the Situation Room. It was a scheduled call. There were other people on the call. There were other people taking notes, and obviously the President was aware of that fact. The House managers talk about the fact that the President did not follow the approved talking points, as if the President, any President, is obligated to follow approved talking points. And the last time I checked, and I think this is clear to the American people, President Trump knows how to speak his mind. But remember the fake transcript that Manager Schiff read when he was before the Intelligence Committee? His mob, gangster-like fake rendition of the call? Well, I prosecuted organized crime for years. The type of description of what goes on, what House Manager Schiff tried to create for the American people, is completely detached from reality. It is as if we were supposed to believe that mobsters would invite people they do not know into an organized crime meeting to sit around and take notes to establish the corrupt intent. Manager Schiff, our jobs as prosecutors, and I know you were one, would have been a lot easier if that were how it worked. Think about what he is saying. Think about the manager's position, that our president decided, with corrupt intent, to shake down, in their words, another foreign leader, and he decided to do it in front of everyone in a documented conversation, in the presence of people he did not even know, just so he can get this personal benefit, and that was not in our country's interest. The logic is flawed. It is completely illogical, because that is not what happened. And that is why Manager Schiff ran away from the actual transcript. That is why he created his own fake conversation. But I would like to just address another point from the transcript of the July 25th phone call. The House managers allege that an Oval Office meeting with the President was critical to the newly elected Ukrainian president because it would signal to Russia, which had invaded Ukraine in 2014 and still occupied Ukrainian territory, that Ukraine could count on American support. They actually argue that it was a quid pro quo, that the President withheld this critical Oval Office meeting that would deter the Russians and save the Ukrainians because he wanted something personal. Now, if that was in fact critical to President Zelensky for the safety of his own citizens, he would have immediately jumped at the opportunity to come to the Oval Office especially when President Trump offered him that invitation during the July 25th call. But let's see what President Zelensky actually says when he's invited to Washington on that call. He does not say, "Oh, this is what I would like to do. It's critical for my people. We will arrange it immediately." His response is, "I would be very happy to come and would be happy to meet you personally and get to know you better. On the other hand, I believe that on September 1st, we will be in Poland and we can meet in Poland, hopefully." In an Oval Office meeting, if an Oval Office meeting was critical to President Zelensky, that was the time to say so, not to suggest another venue. When we look at the evidence that is before us, it is clear that the only people who talked about having an Oval Office meeting were lower-level government employees who thought it was a good idea. But the principals involved, those who actually make the decisions, President Zelensky and President Trump, to them, it was not critical. It was not material, and it was definitely never a quid pro quo. What was important to President Zelensky was not an Oval Office meeting, but the lethal weapons that President Trump supplied to Ukraine and the sanctions that President Trump enforced against the Russians. That is what the transcript of the July 25th call demonstrates. Let us now consider what President Zelensky knew about the support that President Trump had provided to Ukraine compared to the support, or more accurately, lack thereof, that the prior administration had provided to Ukraine. In February 2004, Russia began its military campaign against Ukraine. Against the advice and urgings of Congress and many in his own administration, President Obama refused then and throughout the remainder of his presidency to provide lethal assistance to Ukraine. In the House, Manager Schiff joined many of his colleagues in a letter-writing campaign to President Obama urging that, quote, "the U.S. must supply Ukraine with the means to defend itself," close quote, against Russian aggression, and urging President Obama to quickly approve additional efforts to support Ukraine's efforts to defend its sovereign territory, including the transfer of lethal defense weapons to the Ukraine military. On March 23rd, the House of Representatives overwhelmingly passed a resolution urging President Obama to immediately exercise the authority by Congress to provide Ukraine with lethal defensive weapon system. The very next day,
If you need lumber wood, Lonnie's is better than good. We also have the best selection of plywood in the state. Hey! Dang, woodchucks! Stop chucking that wood!
Geico Sequels. The savings keep on going.
President's mouth that were never there. Again, look at the transcript of the July call. President Trump never asked about any with President Medvedev into Article 1 of the House's impeachment articles against President Trump. Using the powers of his high office, President Obama solicited interference
said you'd answer the question.
So
I said
on this scheme that
hold
you're
on.
accusing Joe Biden
Hold
of?
on, Andrew.
I'm
Let
sorry?
me answer the question. I did ask the question. Why?
So I get that the press loves to obsess over the latest bombshell. Listen, I don't know what John Bolton's book says or doesn't say. I've seen the New York Times coverage, but at the end of the day, it doesn't impact the legal issue before this Senate. The legal issue before this Senate is whether a president has the authority to investigate corruption. So the House managers built their entire case on the proposition that investigating Burisma corruption, investigating the Bidens for corruption, was baseless and a sham. Hold on, let me finish this. No, I'm going to finish my point, and then I'm happy to answer your question. The House managers based their entire case on the proposition that investigating corruption for Burisma and concerning the Bidens was baseless and a sham. That proposition is absurd. We've just seen, they said there wasn't a shred of evidence concerning corruption. We've just seen 2 hours of evidence. And at a minimum, it was not only reasonable and justified, but the president, I think, had an obligation to investigate corruption that potentially extended to the very highest levels of government.
Senator, over those 2 hours, none of the president's attorneys mentioned one single possible crime that Hunter or Joe Biden are accused of. Basically, what they said was Hunter Biden got a job. That was vice president. If that's a crime, I mean, shouldn't half of your children be in prison?
My children are 9 and 11, and I'm sorry that you want to throw a 9-year-old in prison. But at this point, my third grader plays basketball and softball at her school. So stop playing the nasty. No, stop playing the nasty Washington game.
I'm sorry, that's not nasty Washington game. Senator.
Attacking a 9-year-old?
Senator, I have no idea.
All right.
Senator, we've seen reports about a possible 1-for-1, one Republican witness, one Democratic witness. Would you be open to that idea?
Look, in my view, additional witnesses are not necessary. The House managers have presented their case. They haven't come remotely close to meeting their burden of proof. Now, that being said, if the Senate later this week, when we vote on witnesses, decides to go down the road to additional witnesses, I think at a minimum, the most important witness for the Senate to hear from is now Hunter Biden. The House manager made a decision. Let another reporter have a chance.
Why don't you want to hear from John Bolton under oath?
I don't believe the testimony is necessary. The House managers have a burden of proof to prove their case. They have fallen woefully short. The standard under the Constitution is high crimes and misdemeanors. They have not demonstrated any law was violated, and the president was entirely justified in asking for an investigation of corruption concerning Ukraine and potentially Hunter Biden and Joe Biden. At the end of the day, there may or may not have been.
After you see this last hour that we just saw.
Isn't there a shadow over the president if you don't have testimony in a trial?
Look, the shadow over the presidency is the last several months of sham proceedings in the House where they only heard from prosecution witnesses and they ignored the very substantial evidence of corruption with the vice president going to the very top, potentially, of the administration. And by the way, the Obama administration pointed out the conflict of interest over and over and over again, and so did the press until the press decided to defend the House Democrats' partisan impeachment attack. This has been a sham from the beginning. Presidents have the authority to investigate corruption, and there was overwhelming authority. All right, I'm going to let these guys.
Senator Braun, on that 1-for-1 witness question, what do you have to say?
Oh, definitely. We get the witnesses. It'll be a 1-for-1 or a 2-for-2. But all I can tell you is I sat through this last hour, and that was the most powerful presentation on either side. And what it gets at is that the president had every right to look into corruption because he did such a good job of comparing what was overlooked during the Obama administration and how thick the Bidens were involved. In fact, the main takeaway from this is I'm sure now that they mentioned the Bidens 400 times in their own presentation, it's probably the vice president's worst nightmare of how this has risen to that profile.
So was it right to ask for a favor? I mean, that's what it boils down to, not the quick pro quo, but the fact that he asked for a favor from Ukraine.
Did you watch the video of Barack Obama? Well, it sure was
giving advice from the House to Mitch McConnell and my Senate colleagues is normally not a good idea. And so in doing that, my advice to Leader McConnell and to all my Republican colleagues is look at the evidence.
You want them to assess the facts. How can they assess all the facts if Bolton doesn't testify and finally does that at some point in time if he's acquitted? Does it always hang over his head that, hey, you didn't call witnesses in a trial?
One, we've had 12 witnesses, so your premise that we didn't call witnesses.
There hasn't been even
There's been 12 witnesses' testimony presented here in the Senate. There's been 17 in the House. Guys, you all know that I've been through that. Hold on. I'll answer your question. You're from Kentucky. I will answer it, all right? So I remember. So as we look at this, one of the key components to this is to suggest that all the other witnesses combined don't equal one Ambassador Bolton. And that's just not the case. To suggest that Ambassador Bolton is somehow this super witness that would, because of an alleged conversation that he didn't repeat. And I want to stress this. I've talked to some of your colleagues. On August the 27th of this year, Ambassador Bolton met with President Zelensky. Had he been instructed by the president to hold up aid and tie it, he would have communicated that to President Zelensky. He did not. So we know that for a fact. Well, how do we know that? Because Mr. Morrison was there, has testified to that. So whether a conversation happened or not, there was not an action that came from that. The president has said that the conversation didn't happen. Other White House officials have come out to contradict some of the reporting that was done last night. And so I think it's important for the American people that we go ahead and judge it on the facts that we have. So go ahead. Go ahead. Yeah, I don't normally I talk to the president on a fairly regular basis, but one of the reasons why I get to talk to him is because I don't talk about my conversations with the president of the United States.
I want to clarify something you said earlier. Are you alleging
or redirect? Are you clarifying or redirecting?
I was redirect. See if you want to clarify. Are you alleging that Democrats have coordinated this leak to the New York Times?
I have evidence that they leaked when it was over in the House. My hypothesis is that this is part of a coordinated leak in order to change the narrative. To suggest that any particular Democrat did it, no, I can't do that. But I can say that there is a history of my Democrat colleagues leaking to some of you that are around here covering the press right now. I would go out and find that you had documents that I didn't even have access to before. Literally, I was finding out about the documents from all of you. So there is a history of that happening.
But isn't it the substance of what is saying that matters rather than the timing of when it came out?
I think the substance of what the president did and what was delivered by Ukraine is the crux of the matter. Had the Ukrainians actually done an investigation, had the Ukrainians actually provided a deliverable because of some kind of connection, then we would be having a very different discussion. But that didn't happen. And when you have that, the very country who would have had to have been bribed in order for this to actually be an impeachable offense is saying that